Senator Whish-Wilson, you have questions in this area?
Oh, yeah, roughly in this area. Yeah, Mr Fletcher, thanks for appearing today. In terms of some of the evidence that the committee has received, both verbally and in submissions, there are many medical practitioners who feel that the investigations process and notification process can also be seen as being bullying and intimidation. You're aware, and you acknowledged in your opening statement, that these things can put medical practitioners under a lot of pressure and it can be quite stressful for them. On that theme, we received evidence in Sydney from a medical practitioner in Tasmania, Dr Gary Fettke. He gave the evidence to the committee in the morning of our hearing in Sydney. 3 hours later, he received an official caution from AHPRA after a 2.5-year investigation. Can you understand why Dr Fettke, and I've got to say, for him to actually come to Sydney and appear in person was a very brave thing for him to do. Incredible amount of stress and pressure on him and his family. Can you understand why he felt bullied and intimidated receiving a caution 3 hours after giving evidence to this committee?
Let me make the wider point. I think we recognise that the being subject to the notifications process for a practitioner can be an extraordinarily stressful thing, because there are pretty serious issues at stake ultimately in terms of their practice of their profession and
their reputation.
And their reputation. And despite the fact that we are not punitive in our focus, we are protective in our focus, so our mandate is a public protection focus, we understand and appreciate that it may not feel like that for the practitioner involved in the process. And that's why we've done a lot of work to actually look at how, through improved communication, through improving our timeframes, and through the way we manage the notification, that we can alleviate the stress. But I think, I think it is a stressful event.
I appreciate what you're saying. It makes sense, but it is platitudes. I asked you specifically about this incident. Can you explain to the committee how this occurred? Whether it was coincidence or whether it was deliberate, can you explain to the committee why 3 hours later he received a caution after a 2.5-year investigation?
There is no relationship between the two events. The caution is the result of a regulatory process. It's quite separate and unrelated to anything that he might do in relation to his committee or that appearance.
Do you agree it was bad management issuing a caution after a witness had given evidence to a Senate inquiry?
Well, I'm just saying there is no relationship between the two events.
When was the decision made that he would be cautioned?
I'd have to have a look at.
Could you let us know when the board met on that decision? My understanding it was weeks before the email was sent, and I'll be very interested as to why that afternoon, in particular, that email was sent out.
Well, typically, if I can just explain the process, a board would meet and make a decision. There would then be a process of confirming the decisions and action of the board, because it's obviously important from an AHPRA point of view that we have absolute accuracy in terms of the decisions of the board to take regulatory action or not, as the case may be. There would then be a process of the correspondence being drawn up and sent to the practitioner in relation to that board outcome. So that would be the normal process. So it's not. There is always, or there is often, a gap between a board meeting and then the decision being finally communicated to the practitioner for those reasons.
Could you supply on notice a timeline of when those decisions were made, when the board met, how long it took to draft up the letter, all those events that occurred with the timeline? Because I must admit it does look odd that not 3 hours after he appeared before us, he got his caution.
You can imagine how devastated he felt when he received that on email on his phone, having a cup of tea with his wife, trying to settle his nerves down, to suddenly get his caution after a 2.5-year investigation.
Well, again, I just want to assure the committee that there is no relationship between the two events, and we have provided a confidential briefing on this matter to the committee. So whether
I'm very conscious that at the moment I think it's still okay to be public here because the caution.
So perhaps if we could return to this issue in the context of the confidential briefing.
To this line of questioning, presumably there would be management committee notes or notes from AHPRA management leading up to this email to Dr. Fetke and the sequence of events leading up to that. There must be an email trail or notes and the like. Are you in a position to provide that so we can understand why it was that Dr. Fetke received this caution immediately after giving evidence at a Senate inquiry? It does seem to be a rather strange coincidence. We're just I'm trying to understand, I think others are trying to understand how it is that someone gives evidence, the whole circumstance of this contentious matter, and then within hours of giving evidence he gets hit with this this caution from AHPRA. Can you provide us with your, the materials, the notes, the documents leading up to this decision as to how it came to be at that particular time?
Well, again, I would reiterate that there is no relationship between the two events.
I didn't ask that. I just said, can you provide us with the documents?
The caution was the outcome of a regulatory process. We've provided additional briefing to the committee, and
it doesn't have the timeline in it.
Well,
I've asked for the documents. Can you provide the documents?
Let's let Mr. Fletcher finish
sorry,
his
Chair.
comments.
So what you are essentially seeking additional assurance around the timeframe of events in relation to the appearance before the committee. Is that
Yes.
So all right. Well, let me take that on notice then, and I'll see what we can provide in relation to
Including specifically the timeline. Thank you, Chair.
I think it's important to point out as well, in terms of it's not just serious from the witness's personal standpoint, from the committee's standpoint. It potentially is a breach of parliamentary privilege, and if witnesses feel that they have been intimidated or punished, and that's the words that are in Hansard, then it's a potential breach of parliamentary privilege if this has occurred deliberately, and even if it wasn't deliberate. It's very poor management on AHPRA's behalf to allow this to happen hours after a witness has given evidence to a Senate committee. So at least I'd like you to take that on record. We'll accept that it's a coincidence, but if it was very poorly managed for that email to be sent out that afternoon. Could I ask you, on the same theme, about medical practitioners feeling intimidated and bullied by the process? You put out a media statement last week, statement from Medical Board of Australia and AHPRA, 16th of November 2016, that related to Dr. Fetke's caution. Could you tell the committee how long you gave Dr. Fetke to sign release documents to make his files and information public before you put this media release out?
So, this statement does not disclose confidential information in relation to Dr. Fetke. The fact of the caution is already on the public record.
I accept that,
and because that's
it
been
had
put
been
on the
commented
public
on in the
record.
Mercury and other
Our
newspapers.
concern was about the level of misinformation there is about what's happened in this case, but clearly we're not in a position to say more without the consent of Dr. Fetke.
Okay.
We advised him probably an hour before this statement went out that we were intending to release it.
Do you think he's very precise? He says 52 minutes, so it's quite close enough to an hour. But Mr. Fletcher, can you understand a busy surgeon having less an hour to speak to actually know about this, then speak to his lawyers and give you an informed decision on whether you should or shouldn't, whether he should or shouldn't release the documents, is unfair? I mean, you make it very clear in what you're implying in this statement, which was in the newspapers in Tasmania, that he, until he signed over these documents and allowed you to do it, that you couldn't comment on the case, but you're very clearly implying that he's blocking the release of documents in this information. Certainly that's the way he sees it, and a number of other people. How is it fair that you can give someone an hour's notice? Wouldn't it have been a better process to have been let him speak to his lawyers and make an informed decision before you went public with this?
Well, The point that I'd make, Senator, is that our concern is that there is a lot of misinformation in the public domain, not from us, in relation to this matter at the moment, and we are concerned about that. In this statement, we did not seek to disclose confidential information. We simply sought to provide a statement of the framework in which the board considers matters such as this, and we made clear that we could not say more without the consent of Dr. Fetke.
Can I just ask,
please.
why did you put it out with such short notice to Mr. Fetke, given the comments that you made in there in terms of you don't have his permission yet to release the information? Why not wait till you knew whether you had it or not before you made the media statement?
Well, because again, I'd say we have not said anything in this statement that in relation to material that is confidential to Dr. Fetke.
I appreciate. Sorry,
and
Mr. Fletcher, you're not. That is. I understand that.
Well,
You've said it a number of times.
If I could just finish.
It's the point of why make it. The question was why make it so soon after you sent the email. Why couldn't you not wait longer for a response?
Well, the reason we put the statement out because of the level of misinformation there was. We were getting queries from the media in relation to this. There's been very active comment on social media and the like, and so we wanted to move, promptly to at least, in broad terms, set out what the framework was in the way that the board approached these sort of issues. But as I say, going no further than we could without the consent of Dr. Fetke.
Essentially, you did release that information in this media release. You didn't release any documents or anything specific, but you've outlined a number of things here that look like allegations. Certainly, Dr. Fetke feels that he's been slandered and smeared in terms of, for example, you've said the board holds all registered medical practitioners to account against professional standards set by the boards. You say that these standards are set out in good medical practice. And then it says this code requires doctors to make sure their personal beliefs do not compromise the care they provide to their patients, prevents doctors putting their commercial interests ahead of patients' care. You've gone on and listed another 4 things there that are clearly, you're making a statement about Dr. Fetke here. And you're not supposed to be making public statements about him, yet in a sense you are.
Well,
would that be a correct interpretation?
No, I don't believe that is a correct interpretation, Senator. I think what we are saying is the fact that good medical practice is the framework in which the board consider these matters. These are elements of good medical practice that are obviously salient. And the other point that was very key was that the fact that the caution was in the public domain. Dr. Fetke had put that in the public domain, but it was being misreported as a ban or a gag. And we wanted in the further information in the statement to make clear what a caution is and what it isn't.
Look, I'm out of respect and deference to Senator Seward, I'll ask you some more specific questions in camera on this. But in terms of what you just said then, in terms of a gag and a ban, the caution itself, you made it very clear in your correspondence to Dr. Fetke that cautions, and this is our understanding from the evidence we heard in Sydney, cautions from AHPRA are not appealable. Yet in this media statement, you basically say they're appealable to the board of the Supreme Court for judicial review. And they can also make complaints to the National Health Practitioner Ombudsman. Now, this is an issue I hope the committee looks at, whether these things should be appealable or not, cautions, because they are a black mark against the doctor's name, particularly ones who have long-standing reputations and do a lot of hard work for their community. How is it that, on one hand, we can have the evidence, the Senate, that these things aren't appealable? Never. And Dr. Fetke's got to have this against... He can't give medical advice on dietary advice for the rest of his medical career. Yet you say in this media release, any medical practitioner can appeal a decision made by the board to the Supreme Court for judicial review. Are they appealable or aren't they?
So a caution is not an appellable decision under the national law. So under the national law,
Do you mean
the National Health Practitioner Regulation, National Law Act,
I think we need to be
Section 199 sets out the decisions of a board that are appellable, and they are appellable to a tribunal. So there's an independent tribunal in each state and territory, and that effectively is a merits review. Now, a caution is not one of the decisions of a board that is subject to appeal to a tribunal. However, a caution, so this is now outside of the national law, could be the subject of an appeal to the Supreme Court, and that would be a judicial review, not a merits review.
Okay.
And then the National Health Practitioner Ombudsman has no jurisdiction in relation to the outcome of a regulatory process, but she does have jurisdiction in relation to reviewing the administration of that process to arrive at that outcome.
So, for all intents and purposes, Dr. Fetke can't have this decision changed or appealed?
Well, he can appeal. He could go for judicial review to the Supreme Court if he believed, for example, there was some sort of error of law in relation to the way that AHPRA and the board have dealt with this matter. But he can't go to a local tribunal for a merits review.
I'm aware that I have a number of senators who would like to pursue some more detail that I actually think goes to the point where we need to go on camera. So what I'm proposing is that I'll come back. Yep, I'm not cutting us off yet. I'm not going into camera yet. I think what I was going to do is, given what I said earlier, we should do that. Anything we need to do in camera, we should do at once. So what I'm proposing is that matter is now a matter that we put on to the side, so that when we go in camera, and that I think I'll consult and just double check. Do we need 20 minutes in camera or a bit longer? 20?
Yes, I think Senator Wilson will have done a question.
Yeah, okay. So I'm proposing we go in camera at 5 to 6. Okay? We've got a time managed, we're on a...
Sure.
Yeah. Okay. Now, I'm aware that Senator Wilson has a couple of questions that he assures me are still suitable for the current session.
It's a vexatious issue that I'd like to come back to, yeah.
I realise you've had a little bit of time now.
I'm relaxed.
You're relaxed? Okay. And I have a few specific general questions about release of information, and then we'll go back to Senator Xenophon, if that's okay with you. Okay. Do you want to...
Thank you, Chair. In relation to dietary advice, does AHPRA, do you have... well, actually, let's be clear. My understanding is you don't have jurisdiction over the regulation of the Dietitians Association of Australia or dietary advice. Is that correct?
Yeah, dietitians are not a registered profession in Australia.
Okay, so they're self-regulated. Okay, so if you don't have jurisdiction over dietary advice, what I don't understand, I think the committee don't understand, is why you've conducted an investigation for 2.5 years. You've gone down a very long rabbit hole against a surgeon for essentially providing dietary advice to patients. Where's your jurisdiction if you don't have it over dietitians? Why are you pursuing this against a medical practitioner?
Look, as you can appreciate, it's difficult for me to comment on an individual matter.
Let's just talk broadly about
in
dietary
general
advice.
terms, we would only investigate a matter where there was a question about patient safety or public safety which may require some sort of regulatory response on the part of the board.
Right, okay, but you don't think it's a matter of, and it's not your fault, Mr. Fletcher, but I understand the government made a decision for the dietitians area not to be regulated. We've received correspondence from the Dietitians Association of Australia because it was in relation to evidence that Dr. Fetke gave publicly. In their letter, they state to us, it was also mentioned that dietetics is not regulated in AHPRA, which is correct. Dietetics is strongly self-regulated, and the fact that the profession is not part of the National Registration Accreditation Scheme was a government decision. As we understand, dietetics has not been considered for registration under AHPRA due to the low risk our profession poses to patient safety. Now, there's been no case of patient harm in relation to Dr. Fetke. The dietitians themselves are saying it's a low risk area. Why have your time and resources been tied up for 2.5 years pursuing a surgeon who has spent 30 years cutting limbs off patients because of diabetes and obesity and wants to tackle that problem in a holistic way. Why have you gone down this rabbit hole for 2.5 years?
Again, Senator, I'm going to be careful what I say about individual matters in this hearing, except to really just repeat the point that I made, that an investigation is undertaken where there are a set of issues that raise questions about public safety or patient safety that may require regulatory action.
Now I will ask more specific questions in camera, but just quickly, because I know other people have questions to ask. In relation to this issue about vexatious claims, you stated 3 terms in your opening statement that Senator Xenophon's alluded to. You talked about rivalry, commerce and emotion. Do you accept that in the case of the Dietitians Association, and Dr Fettke's made it clear in public evidence that they're the ones who have lodged a complaint against him. He's also told me that a senior dietitian at a conference told the whole conference that when asked about his diet publicly, we are silencing him. Don't worry, we are silencing him, which referred to their referral to you for an investigation. How can that not be rivalry, commerce, clearly a turf dispute, and given the social media impact and dimension of this case, emotion? Dr Fettke's admitted he's been involved in social media, let's say, exchanges over a long period of time, but how can all those 3 things not, what you say, vexatious? How can this not be a clear example of a vexatious claim against Dr Fettke?
Maybe I'm aware of.
I'm sorry, I feel like I'm repeating myself.
I know, but hang on.
It's frustrating.
Can you expand that into then, if you feel like you can't answer specifically on that one until we go in camera, the issue is still pertinent because this may not only be an issue for this particular example that we've been talking about, in terms of how do you make those calls?
So, as I said in my earlier comments, on all of the available data and evidence, this is a very small percentage of the matters that we see. And if a board came to a view that a matter essentially lacked substance, that there was no basis for the notification or complaint, it would close that notification or complaint without any further action. If the nature of the behaviour of the notifier gave rise to concern, then it would be open under the national law for a board to take own motion and to effectively investigate the conduct of that practitioner in making the notification as something that raises questions about public and patient safety.
So I'm, with all due respect, I'm none the wiser about how you make those calls on what is, and I know that we've got to be careful about particular cases, but perhaps we'll leave that one and come back to it as an example.
Well, perhaps, I mean, each matter, every notification we receive, we assess. So we look at the information provided by the person who's made the notification. We often talk to the notifier to get any additional information. We would then make that information available in most cases to the person who is subject to the notification and seek a response from them. And then on the basis of that information, we would make a decision about whether something had some basis that may require further investigation. In some cases, if it's a very serious risk, it may require immediate action on the part of the board. In other cases, it may be as a result of the assessment the matter is closed because there is no need for further regulatory action. And I looked at our data for 2015-16 prior to coming here, and in fact we close around 59% of matters following assessment. So the majority of matters don't necessarily go into investigation.
59%.
Yeah, now that may be, it doesn't mean that there wasn't an issue, but what it's saying is that there isn't necessarily an issue that requires a regulatory action because the national law, as I said, it's a protective jurisdiction, and the national law requires us to do the minimum necessary to appropriately protect the public. There are also circumstances where when the concern is raised, the practitioner themselves take steps voluntarily to address the issue, and therefore there is no need for the board to take any further action.
Mr. Fletcher, just to ask you for if you're able to say this, in terms of the dietary advice that Dr. Fetke was offering patients, and he's never denied that. He's got a business that was set up that offers dietary advice that employs dietitians. Like a lot of doctors, he's vertically integrated his business and provided another service. Did you seek advice from the CSIRO about the low carbohydrate diet? And have you spoken to the Australian Medical Association during the investigation to seek advice on whether what he was advising patients was in fact harmful?
Again, I'm going to not comment on an individual matter. It's not that I don't want to be helpful, it's just that the national law puts very strict confidentiality requirements in relation to what I'm able to say.
Okay, thank you. Senator Xenophon.
Can I just ask in terms of, again, I know you don't want to talk about specific cases, but just in terms of how do you prioritise it? So if we just talk perhaps in hypothetical terms, if patients aren't complaining about a doctor giving advice, a medical practitioner giving advice, that there is nothing improper about that advice, that it might relate to dietary matters, how do you decide whether the complaint is, if not vexatious, is so trivial that you don't go down that path? I mean, presumably you have limited resources. You can't investigate every complaint, can you?
That's correct.
Right. So let's just go through this. How many complaints do you get each year involving doctors, and how many of those complaints do you investigate? And how do you determine whether you investigate a particular complaint or not, including, for instance, and again, not referring to any specific cases, I'm not trying to be cute about this, but, you know, if you've got patients aren't complaining, a doctor is saying, watch your diet because, you know, you'll have adverse health outcomes and you should eat, you know, follow the CSIRO diet or whatever it is, but, you know, just some reasonable advice. And then you get others who might have some commercial issues complaining about that. I mean, how do you decide whether you're going to raise a complaint about that compared to, say, a doctor who says incredibly belittling and offensive things to female medical students, basically saying their place is in the kitchen, and you may have seen the evidence, the Hansard of that from the Medical Students Association, or doctors who may be putting patients' safety or their health outcomes at risk. How do you get that balance right? So how many complaints do you get, and how many do you actually act on?
So I'll use the data from 2015-16. So if we include New South Wales in the data, there were just over 10,000 complaints about registered health practitioners in 2015-16.
Involving 10,000 practitioners or less than 10,000?
10,000 notifications.
Involving how many practitioners?
I couldn't tell you that. I'd have to take that.
Because you might have 20 complaints against one doctor.
That's correct. So it's over 10,000 notifications.
Yeah.
And then if you exclude New South Wales, because as you know, we do not deal with notifications in New South Wales, they'll deal with through a separate arrangement. There were just over 6,000 notifications, 6,056 across Australia. Around 53% of those, just over 53%, were in relation to medical practitioners. So just over half of our notifications relate to medical practitioners. And that has been a pretty consistent pattern throughout the life of the national scheme, and medical practitioners represent just about 16.5% of the registered health professions in Australia. So there's about over 100,000 registered medical practitioners in a cohort of about 657,000 registered practitioners across the 14 professions. What we would do when we receive a notification is that essentially we would, as I say, look at the information provided by the notifier, and we would often talk to the notifier to see if there's any additional information. We would then provide that information to the practitioner who is subject to the notification. There are some exceptional circumstances where we may not do that. For example, if there was a police investigation underfoot and there might be sort of questions about action that police might be taking. We risk assess the information because we have powers under the national law for a board to take immediate action if there's a concern about immediate risk to patient safety.
There's a risk assessment matrix, is there?
There is a risk assessment a framework and...
Is that something you can provide to the committee, or is it confidential?
We can provide information about how we risk assess.
Right.
And then...
Can you provide that to us? Is there a risk assessment? Is it possible for us, before we go into Canberra, to provide us with that risk assessment? Is it something that you can email to the committee, or get someone?
Well, I can certainly talk you through how we assess risk.
Yeah, but is there a document that relates to risk assessment?
There are documents in our procedures, but I probably can't get it to you in the next 10 minutes. I'd have to, but I can certainly talk you through the risk assessment process. And then the information, then a board or its committee would look at that information with reference to the relevant standards and codes. So it always comes, this is where the code of conduct is so important, because that is the reference point in terms of saying that this potentially raises issues about public and patient safety related to these elements of the code. And then on the basis of that, a board may decide that there is nothing further that they need to do and close the matter. And as I say, we close the majority of matters at assessment, or it may decide to investigate further. And that often that means that we may seek additional information as part of the investigation process. We also have pathways under the national law where there are questions of impairment, to have a health assessment done of the practitioner, or where there are concerns about performance, to have a performance assessment done about the practitioner.
But if a doctor, as a general principle, if a medical practitioner is giving advice to patients about their diet, in other words, to reduce their health risks in terms of obesity, is known to carry with it all sorts of health risks, correct? I don't expect you to give me a medical opinion, but it's common knowledge. Would you accept that having too much weight on you is not a good thing?
Yeah.
Okay. And if a medical practitioner is advising patients not to go on some, lettuce leaf diet or whatever the hell the latest, diet fashion is, but just a sensible, medically accepted dietary program to reduce weight, why would you risk assess that and have all guns blazing? Haven't you got better things to do?
Well, I don't think all guns blazing is the right characterisation, because if we had a major concern about patient safety, a board would take immediate action that could see restrictions or indeed suspension of the practitioner occurring immediately because of an immediate risk to public or patient safety. But again, the wider...
Well, you did take aim at this particular medical... you do take aim against particular medical practitioners, it seems, for something involving dietary advice.
I don't believe we do take aim at particular medical practitioners. What we do is look at the information, the board looks at the information in front of them, comes to a view about, as I say, whether there's a question that may need regulatory action or may need further investigation, and then that process occurs. And that is what happens.
Has some questions that are not on this particular topic, but moving on.
Just about the processes and individuals that within the organisation. Thank you, Chair. Look, very briefly, I know we've got very limited time before we go into camera. On page 20 of the document you've provided to us today, it refers to, under the section performance assessment, it mentions that the assessments are carried out by one or more independent practitioners who are not board members. Those individuals, where are they chosen from? Who chooses them? Is there a register of medical professionals that you refer to when you need to conduct one of these assessments? And how do we ensure there's no conflict of interest or something like that? Do we weigh on the individual you may be seeking to do the assessment to fess up to a conflict, or what do we do?
So we have a panel of, so we have a number of arrangements. So we have people available on a panel who are available to do assessments. And one of the benefits, I think, of being a national scheme is that we can go outside a state or territory if we need to get somebody, who isn't directly involved with a particular practitioner. The other area that we use independent experts is through getting expert opinions. And often that might require us to get somebody who has got quite a specialised area of knowledge around a sort of medical subspecialty, for example. So again, we would often seek advice from the relevant professional college or medical college about an appropriate expert to source, and then we would When we do that, we do not disclose the name of the person. But obviously, once we are approaching an individual to do the assessment or provide the expert opinion, we do disclose the name, because we then need to establish that there is no conflict of interest that may mean that they're unable to do what we need them to do.
Okay, all right. Thank you very much. At the last set of hearings we had, where we spoke to AHPRA, I asked a couple of questions and put them on notice around how many medical practitioners are employed in the investigations team. Now, some answers have been provided which give us an overview of how the staff is structured, and it talks about the 180 staff in the notifications division across the country, 42 with clinical background, but it goes across nurses, midwives, psychologists, pharmacists, physiotherapists, etc. How many specifically, though, are medical practitioners within that? And you may need to take that on notice.
Yeah, I would need to take that on notice, but I would make the point that
I know you do a lot more.
As it relates to medicine, the decisions are made by state and territory boards of the national board and their committees, and that always comprises practitioner members, so medical practitioners as well as community members. So,
my interest is very much in the investigators, those people who are there looking at the information that's being presented, because they have to have some understanding of what I would imagine, not having a medical degree or any experience in midwifery or anything like that, to be very complex. So I was just particularly, though, interested in those with a medical degree or that sort of experience. And then just on the, the selection criteria, page 15 of 17 in the answers to questions on notice, it refers under the section qualifications and experience, required qualifications, relevant tertiary qualification, for example, lawyer, journalist or health practitioner. That's obviously not an exhaustive list of, I mean, in terms of the threshold, is it anything? Could you have an arts degree? I suppose you can if you can be a journalist to be an investigator. How many have, it comes back to that other question I've just asked, how many actually have a medical or nursing degree out of your investigators? So if I could...
So what we've said is 1 in 4 of our notifications division have some sort of health practitioner background. But what I understand you to be asking me, Senator, is to narrow that down to nursing and medicine.
Yes, if you could break it, so within those 42...
What is the professional background?
What is the breakdown by? Yes, if you could, that would be very handy. Thank you very much. And look, in the interest of time, I know we have to go into the... Thank you, Chair. Thank you, Mr Fletcher.
Did you had one short question?
Yeah.
I understand.
Look, it was a question in relation to, once again, the media release you put out about Dr. Fecchi and misinformation being out there, or being reported, I think was the words you used. I was just wondering if you could tell the committee how many FOIs Dr. Fecchi had applied for, certainly starting with AHPRA before going to Ombudsman or another organisation, to have some of his documents released publicly.
How many applications he's made to us for FOI? I'd have to take that on notice, Senator. I don't know that off the top of my head. How many? I know he has made applications, and I understand there are they are currently under.
Do you think it might have been worthwhile letting people know in your media statement that he has actually tried to get some of his documents released publicly without you saying he hasn't signed over permission, implying that he doesn't want them released?
Well, I don't think we are implying. I think we're basically, it's a statement of fact that unless he consents, we can't release further information.
But you
said one, and you're eating into the in-camera time, and I think we're getting close to what we need to talk about in camera. Okay? So if everybody's now agreed, we will go in camera.